Welcome to Vskills YouTube channel. In this video, you will learn about the top interview questions for contract law. So, let's get started. Question number 1. What is a contract? The answer is, a contract is a legally binding document between at least two parties that defines and governs the rights and duties of the parties to an agreement. A contract is legally charted because it meets the requirements and approval of the law. Question number 2. What are the contract elements? The answer is, for a contract to be legally binding it must contain 4 essential elements. First, an offer. Second, an acceptance. Third, an intention to create a legal relationship. Fourth, a consideration, usually some asset. Question number 3. Explain the Indian Contract Act, 1872? The answer is, the Indian Contract Act, 1872 prescribes the law relating to contracts in India and is the key act regulating Indian contract law. The act is based on the principles of English common law. It is relevant to all the states of India. It determines the circumstances in which promises made by the parties to a contract shall be legally binding. Question number 4. In how many sections is the Indian Contract Act, 1872 divided? The answer is, the act as enacted originally had 266 sections. General Principles of Law of Contract, Sections 1 to 75. Contracts relating to sale of goods, Sections 76 to 123. Special Contracts, Indemnity, Guarantee, Bailment and Pledge and Agency, Sections 124 to 238. Contracts relating to partnership, Sections 239 to 266. Question number 5. What do you understand by contract of indemnity? The answer is, a contract by which one party promises to save the other from dropping cause to him by the contract of the promisor himself, or by the conduct of any other person, is called a contract of indemnity. Question number 6. List the requirements of a valid offer? The answer is, following are the requirements for a valid offer. Must be firm. Must be complete. Must be clear and certain. Must meet the requirements of the Consumer Protection Act. Question number 7. List the requirements of a valid acceptance? The answer is, following are the requirements for a valid acceptance. Must be unqualified. Must be by the person to whom the offer was made. Must be a conscious response to the offer. Must be in the form prescribed by the offerer, if any. Question number 8. What is contract of guarantee, surety, principal debtor and creditor? The answer is, a contract of guarantee is a contract to do the promise, or discharge the liability, of a third person in case of his default. The person who gives the guarantee is called the surety, the person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. A guarantee may be either oral or written. Question number 9. What are the ways in which an offer may be terminated? The answer is, an offer terminates in the following ways. Rejection of the offer. Acceptance of the offer. Effluxion of the prescribed time, or of a reasonable time. Death of either party. Revocation of the offer. Loss of legal capacity to act. Question number 10. Which Indian state is exempted under the Indian Contract Act, 1872? The answer is, Jammu and Kashmir is exempted under the Indian Contract Act, 1872. Question number 11. What is the International Commercial Law? The answer is, international commercial law is a body of legal rules, conventions, treaties, domestic legislation and commercial customs or usages, that governs international commercial or business transactions. Question number 12. What is regional trade blocks? The answer is, a regional trading bloc is a group of countries within a geographical region that protect themselves from imports from non-members. Question number 13. What is UNCITRAL and what is its purpose? The answer is, UNCITRAL is the central legal body of the United Nations' system in the field of international trade law. The core function of UNCITRAL is the modernization and harmonization of rules on international business. The organization is responsible for helping to facilitate international trade and investment. Question number 14. What does Incoterms 2010 mean? The answer is, Incoterms 2010 refer to the issue of transporting products from the exporter to the importer. Incoterms also include carrying products, covering the costs of transport itself, insurance costs, cost of risk transfer for the condition of products at various points in the transport process. Question number 15. List the different types of international contracts. The answer is, there are different types of international contracts. International distribution agreements. Intellectual property licenses. Investment agreements. International sales contracts. Supply agreements. Letters of credit. Franchise agreements. Joint venture agreements. Development agreements. Question number 16. List the 10 major regional trade blocs across the world. The answer is, these include the ASEAN, APEC, BRICS, EU, NAFTA, CIS, COMESA, SAARC, Mercosur, EURARC. Question number 17. Define pledge, pawnee, and pawnee. The answer is, the bailment of goods as security for payment of a debt or performance of a promise is called a pledge. The bailer is in this case called the pawner. The bailee is called pawnee. Question number 18. What is the main objective of the Specific Relief Act? The answer is, the main objective of the Specific Relief Act is that no person shall live with the damages and losses, and those who have caused such a situation must be in a position to restore all unlawful benefits received by them. This act focuses on providing justice to all and not on just favoring a single party. Question number 19. What is a breach of contract? The answer is, a contract is said to be breached or broken when one of the parties fails or denies to perform his obligations or his promise under the contract. Therefore, it can be said that when a binding agreement is not honored by one or more parties by non-performance of his promise, the agreement can be said to be breached. Question number 20. What are tacit terms? The answer is, a tacit term is one that the parties did not specifically agree upon, but which both or all of them expected to form part of their agreement. It is a wordless understanding having the same legal effect as an express term. Question number 21. What is lapse of time in contract law? The answer is, lapse of time operates to discontinue an offer in which the intended recipient does not respond to it within the time stipulated therein or within a reasonable time. Question number 22. What is discharge by mutual agreement? The answer is, if both the parties to the contract, expressly or impliedly, agree to terminate the contract is said to have been discharged by mutual consent. Question number 23. Define a bailment. The answer is, a bailment is the transfer of goods by one person to another for some purpose, upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. Question number 24. Briefly discuss compromise. The answer is, compromise is an agreement in terms of which parties resolve a dispute or some uncertainty between themselves. Compromise differs from true novation in that compromise does not require a valid old obligation to have existed. Question number 25. State the ways in which obligations may be terminated. The answer is, following are the ways in which obligations may be terminated: by performance, agreement, release and waiver, novation, compromise, effluxion of time, notice, by law, set off, merger, supervening impossibility of performance, prescription, insolvency, death. Question number 26. What is misrepresentation? The answer is, a misrepresentation is overall a false statement of past or present fact made by a contractual party to another before the conclusion of a contract and regarding some matter or circumstance relating to the contract. Question number 27. What is the parole evidence rule? The answer is, the parole evidence rule tells that where the parties intended their agreement to be fully and finally embodied in writing, evidence to contradict, vary, add to, or subtract from the terms of the writing is inadmissible. Question number 28. Define coercion. The answer is, coercion is the committing, or threatening to commit, any act as forbidden by the Indian Penal Code, 45 of 1860, or the unlawful detaining, or threatening to detain, any property, to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement. Question number 29. What is undue influence? The answer is, a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. Question number 30. State the devolution of joint rights. The answer is, when a person has made a promise to two or more persons jointly, then unless the contrary intention appears from the contract, the right to claim performance rests, as between him and them, with them during their joint lives, and, after the death of any one of them, with the representative of such deceased person jointly with the survivor, and, after the death of the last survivor, with the representatives of all jointly. For more such videos, subscribe to our channel.